out how to get him served with this, right? I used to be really nice about serving people. I used to send them this very polite, sweet little letter. Please come sign an interview appearance in my office. I promise I don't want to serve you. My professional mentor, who retired in her 80s and was a brilliant lawyer, said she never had to have people served. I think that's a lie. I've gotten kind of cranky about it because they never do it. You know, I'm tired of offering them really nice, easy options and them not taking it. So I would consider whether you're going to get him served via sheriff or constable. Certified mail is going to be tough. You could not serve me by certified mail because I'm never home. Who's home when the mail comes, right? I mean, I think about this all the time. They're like, oh, I served them by certified mail. I was like, really? Who is at their house when the post office comes? I don't know.
So I don't
Are you at your house when the post office comes?
No, sorry. And I don't want to derail the conversation with
Please.
hypothetical, but really quickly.
Yeah.
What do you do when someone, like, I know a real life example of someone evading service by leaving the country? Is there a certain amount of time that can elapse where somebody can just get divorced even though someone on the other side hasn't ever been served?
Sure, that's a great question. So this is a question about what can you do if you never, ever get him served, right? Maybe he flees the country, the jurisdiction, yeah. You have some options at that point. You can certainly eventually ask the court to appoint a warning order attorney. Anybody been a warning order before? We all know it's sort of a mixed bag on quite how much service you get out of that, quite how much effort you get out of that. That does put him constructively before the court, so you can then do a couple things. Here's the key thing, and there's an old case about this, and it's a Fayette County case, back when Judge Overstreet was on the bench. I can't remember the name of it. But constructive service is not good for a personal judgment against the guy. So you probably cannot get a judgment for support or maintenance or property at that point. You can get her divorced, you could change her name, you could deal with custody and time sharing, but you probably can't deal with the financial side of this. There's a couple things to keep in mind too. I promise I won't go off on this huge tangent about this, but you do not need personal jurisdiction over a parent to enter a custody order. There's this very funny little line in the UCCJEA, which is the Child Custody Jurisdiction Enforcement Act, that blew my mind when I was a baby lawyer, and I read it, and it said, personal jurisdiction over the respondent is neither sufficient nor required to make a custody order. Blew my mind. I thought, that can't possibly be true. You have a constitutional right to parent your child. But it's true, it's the act. So you can deal with custody without getting him served. She can change her name for sure. And I think you can dissolve the bonds of the marriage, but to ever get money out of him, and frankly, Susie needs some money, you're eventually going to have to find him and get him served. Yes, Jeremy?
I don't know how far this is going to go, but in New Jersey, a husband had for months, if not years, evaded service by constable, by mail, by email.
Yeah.
And a judge ruled that since he's on Facebook all the time, he can be constructively served that way. And he was, and it held up at least over there.
Yeah.
Do you see that expanding at all, or do you see any problems in general with that?
Well, here's the thing. I could see that, God forbid I were the judge, I would be reluctant to deem somebody constructively conserved outside the rules. I think at least around here, that would be the case. I think in the areas where I practice, we have very rule-intensive judges, you know. We have some great judges who practice some real law and know the civil rules and kind of expect them to be followed. At the end of the day, if he's still just constructively served, he's still just constructively served. You haven't, I don't know that expanding constructive service is really the answer, right? I mean, it's helpful. You can get her single, that's good. She can then file a tax return, claim the kids, get some refundable tax credit. It's not nothing, okay? I don't want to belabor that point, but I think until we get to a point where we can actually serve people, not constructively, but actually serve them in a broader way, I think we're always going to be kind of doing half measures. Ross's personal opinion about it. So that's just my opinion about it. So you got to get them served. The options for that we've talked about pretty well. If he's out of state, you have to use the Secretary of State. Just read the rule. Make a little note that says, if my guy is out of state, I will read the rule. Because most people don't know the rule and they remember it wrong, and I can't tell you what it is off the top of my head. But I've done it a couple times, and I've had issues in cases where I've represented people who were out of state and were served via the long arm statute, and it was done incorrectly, and it's a whole nightmare to try to clean up even when everybody's getting along. So just make a little note that you'll read that and you'll follow it. The other thing we want to talk about is, and we kind of glossed over this, when you go to file, she has no money. How are you going to pay the now $225 filing fee? Vince isn't here. We can fuss about it being raised to $225 in Fayette County. So how are we going to get this paid? Do we get it waived? What do you all think? I'm sorry?
A waiver?
A waiver, yeah. So you want to file a motion to proceed in form of papyrus. You will probably, if you don't have one, call me or find one. They're pretty simple. Somebody want a legal aid can hook you up with that, right, Josh?
Yeah, absolutely. I can't speak for the other programs, but they're Legal Aid and Bluegrass. You know, we're there to provide support and any sort of documents like that you need help with. We'd be more than happy to provide.
Yeah. And here's a tip. If you are doing this pro bono through a legal aid pro bono program, you would be very wise to note that in your pleadings. My very first job was for a judge, and I thought it looked kind of stilted and pretentious when I was reviewing them in the judge's office. I thought, that asshole just wants credit for doing pro bono work. What a jerk, blah, blah, blah. But here's the thing. It lets the judge know they can't afford a lawyer, and it is very helpful in getting that filing fee waived. I recently took over a pro bono case that somebody else had started, and the client is profoundly poor. I mean, she's got nothing. And for some reason, the judge did not grant the in forma pauperis motion. And I was having a really hard time figuring out, God, why wouldn't the judge do this? And so I went back and went back and went back. Well, the judge thinks he's paid a lawyer. She's paid a lawyer because it's never been noted in the program that she's getting free representation. So I think it's a signal to the court that you're dealing with a really poor person, an actual bona fide pauper, and not somebody just trying to get out of $225. Yes?
Does informal pauperis only waive the service fee or the filing fee, or can you also get like a sheriff's $40 service fee waiver?
Here, it waives both. So, and I assume this is statewide, but it waives the filing fee. It does waive the service and process fee, but you're then stuck with a sheriff, not a constable, at least here. That's my understanding. Yes, ma'am.
I do a lot of work for VLAC, volunteer law use
Yeah.
through Alfred. And I've never put in there that I'm doing that as a pro bono case. So most of the time they get approved. Is there
Yeah.
something I should be listing that I'm doing it for Alfred?
Sure. So the question is is about listing your pro bono status. You know, I may have spoken too quickly. I think that is a personal decision. You obviously don't want to do anything that's going to offend your client or demean their dignity. You want to treat them with a lot of respect. My problem is I've worked at some really fancy law firms, and for a long time people had the perception that if I showed up, somebody could afford things. You know, I mean, if I show up in some, especially if it's not in Fayette County, if I show up, I mean, the client is assumed to be rich. And so I kind of have to fix that problem, right? I mean, they're thinking, oh my God, they're paying a $250 an hour lawyer. You know, they've got money. So I think it depends on your personal situation a little bit. And, you know, you might want to talk to the client about it. I don't want to do anything that's going to embarrass them. Yes, ma'am.
I was just gonna say, just on that caveat, even if you do for the Court of Appeals, you should put in there that you are, if you're appointed or doing it that way, because I had a decision come down, I was appointed on the case, they went through, if you was a private attorney, you should do this. I was like, but I wasn't, so I couldn't withdraw. But they just automatically assume, so put that in there too, just as a note, so that they know that.
Great.
That does change things sometimes.
Absolutely, no, thank you. That comment was to make sure that also applies to your Court of Appeals opinions, if you're submitting your Court of Appeals cases. And you're right, I mean, judges are human beings, right? And our judges are judges and juries. They're our trier of fact and our judge. And so their opinions can be shaped in lots of ways, big and small. I used to be super concerned about that all the time. I used to vary my cufflinks by the judge. It turns out they're too busy to care. Nobody notices when I wear cufflinks that I think they'll like. But the opinions are going to be shaped for better or worse. You know, there's been so much implicit bias training lately. I don't know if that's on your topic today. Find an implicit bias theory, go to a good one. But there is definitely a perception about that, and you don't want, because the other thing at the Court of Appeals is I've twice appealed a case I did not try. I will probably never do it again, because the Court of Appeals takes the trial attorney to task, and it comes off on it's you, right? And they're like, well, she didn't do blah, blah, blah. And I'm like, it wasn't me. I would have done it. I begged the judge to let me retry. And it hurts our little egos, right? I mean, we're just there trying to help this client, trying to do the right thing, trying to get them some relief from a bad judgment. So I appreciate that. That's great. All right, so you've got your service fee waived, you've got your case filed. let's say magically somehow we got him served. Let's say we gave the sheriff's office the work address and they were able to serve him at work at just the right moment. So we got personal service, actual personal service. We had Joe before the court. Before we go into what to do next, what are you gonna do when Joe calls your office? And it's like, hey, jerkface that served this petition on me that says my wife wants divorce and custody and maintenance. I'm fine with divorce, but I don't want custody and maintenance, and she's good for nothing, and she's lied to you, and you need to know she's lied to you, and I want to tell you that I'm not going to agree to this, and she's lied to you, and I lied, and she's deceitful, and she had an affair in 1982. You know, I mean, this happens, right? Pro se people call us. They call me sometimes. I'm stereotyping a little bit on that conversation, but it's not too far off, right? Pro se people call you. They're going to be. Most likely, Joe's going to want to be divorced as cheaply as possible and not have to pay a damn thing, right? I'm painting in broad strokes, very broad sexist strokes. Please cover your ears if you are a gender theory scholar or something. But 9 times out of 10, if in a heterosexual marriage, the wife is going to be absolutely driven by that time-sharing schedule, and the husband is going to be absolutely driven by the child support number. And our legislature has made sure that those will go like this now, so it will be really hard to settle anything. But that's probably what he's up to. Be prepared for that call. Be nice to him. Be courteous to him. Tell him he should get his own lawyer. Remind him till you're blue in the face that you don't represent him. Maybe tell him in writing. Maybe send him a Facebook message that says, I do not represent you. Be it. But I think that you want to be courteous with them because you do want to build enough goodwill that you can settle this thing, right? I mean, we're teeing up to go to court. We might get her some temporary relief in the courthouse. But even if you do that, at some point, it's going to have to come in for a landing. Okay, so hear this if you don't hear anything else I say. When I was a brand new lawyer, so I worked for a judge, so I'd only ever seen the court side of things. I'd never seen what happens outside the courtroom. I won a lot of temporary motions. I thought that to get anything done temporarily, you had to file temporary motions. I filed real aggressive temporary motions. Some of them were beautifully written, well-researched, works of art that I'd put my soul into. And I won almost all of them. And then you couldn't do a damn thing afterwards because the guy was so mad about me having won that child support and maintenance and don't be mean to the kids motion that then they can't get divorced. He won't go to mediation. He won't play ball with me. He won't send me an offer. She can't afford a trial. You're stuck a little bit. You can win your way into a corner. So that's just random practical advice from Ross. I won my way into a corner a whole bunch when I was a baby lawyer. So I don't run to the courthouse quite so quick anymore. I still go plenty, but I'm not there every week. The lawyers that think I'm there every week probably think I'm unemployed. But be careful with your tone. Be careful how strident your writing becomes. Remember that this is a court of law. Remember that you are a real lawyer. Feel free to sound like one. Be respectful, be courteous, because at the end of the day, you're only going to get divorced one of 2 ways. You're going to have a final hearing, which you don't want to have if you're not getting paid, frankly. It's going to be a lot of time you don't have to give. Or you're going to have to come up with an agreement, and this guy's going to have to sign it. So those are your 2 ultimate exit paths. I think you do well to keep in mind which one you want to be on when this is all said and done. Please don't take that to say that I think that you should leave children in an abusive situation, spouses in an abusive situation. Please don't overread into that. But for sort of normal people going through the process, eventually they're going to have to calm down and settle. And when you don't have a financial incentive to do so because they're not writing you a check every month, it's really hard to get them to do it. So, all that said, sorry, that sermon is over. So you at this point need to do something. So he's not going to pay. He might want to be divorced. She's got to get some money coming in, right? I kind of don't care whether we call it child support, maintenance. We can call it a banana. We can reserve the characterization for later. She needs to get some money coming. So you're going to want to file your motions. I'm on sort of the bottom of page 71 of your materials. You're going to want to file for child support for sure. You're going to want to run a child support guidelines worksheet and see what that comes out for her. I did not do that. How many of you have run child support worksheets before? Okay, so a good amount of you. It's fairly simple. They're online. They're not too hard. I'm spoiled. I have a paralegal that has done all of mine for 5 years. It's pretty great, I'm not going to lie. It's kind of grunt work, but it's out there. just do it, is the long and short of it. These people's child support should be fairly simple. That's part of why I kept it this way. He's a W-2 wage earner. It should not be too hard. Even as a 1099 wage earner, hers should not be too hard. The fight you're gonna have is when she has to start cutting those hours at the part-time job because he's not around to ever watch the kid. Is she or is she not voluntarily underemployed? You're gonna have a little fight about that maybe, but there's not a big fight about this. Anybody have thoughts on whether she might be voluntarily underemployed if she cuts those hours? Yes, ma'am.
The child is 3.
Yes, yes,
So
bravo.
if she's under, she doesn't have to work.
Excellent, very good. We have a winner in the back. If you are caring for a child of the marriage who is 3 or under, you are not voluntarily underemployed, end of story. There's no way for you to be voluntarily underemployed. I, for years, thought the rule said under 3, but if you read it really carefully, it says 3 or under. I was cutting people out of a whole year. So read the statute carefully. That's great, good job, very, very well done. So you want to file your child support motion, you'll need to share her income. So the statutes and the rules say you're also going to have to give the court his income. You're not going to have anything, right? This guy maybe he left some stuff in the house when he ran off. He ran off in a huff. You might have last year's tax returns in a box in the attic or something. But most likely you're not going to have much. You're going to have her swear an affidavit to the best of her knowledge and belief, and that's going to get you over the hurdle to get you into the courthouse. Temporary maintenance is interesting, I think, in this case. I think it's important that you know that spousal support and maintenance are not just for the 1%. There are a lot of 99% maintenance cases out there. When I worked at a Guest Mattingly in Atchison, I had the absolute pleasure of practicing law with the late Justice Jim Keller, and he did a CLE every year that is a survey of all the maintenance cases, published and unpublished in Kentucky. And I'd have to go read them. I'd have to read every opinion, published and unpublished, just to see what the hell people were doing. Because we don't have a maintenance statute, right? So we're in super discretion land. So we would do this survey every year, just what are people getting? What are they awarding? What are they getting? The main takeaway is in Jefferson County, everybody gets it and everybody appeals it. And that's all you can figure out. The rest of the county, it's hard. The rest of the state, it's hard. But you would see maintenance payments that were like $300 a month to make the Jeep payment, or that were $250 a month to make the medical bill payment. So they're out there. It's definitely possible. If there's a gap between her reasonable needs and her ability to support herself, I think you ought to ask for maintenance. I don't think you need to be shy about the fact that he's only making $48,000 a year. Now his take-home pay is going to be interesting, and his ability to pay it's going to be interesting. And here's the little secret that we don't like to admit. Ultimately, you've got a piece of paper saying he has to pay it. I have one time in 10 years had somebody thrown in jail for failure to pay temporary maintenance and held in contempt, and he spent 33 days in prison, actually, or in jail for his contempt. Judge Stein left him there for 33 days, and he did not pay temporary maintenance as ordered, but it was really blatant. I mean, really blatant. In fact, he could have just signed over a bank account to my client and not had to pay the thing. His ability to pay was really, really clear. So yeah, I think personally I would throw it in, and I'd be willing to negotiate for a good number to go away, and then just not have to worry about it. Another trick, if you've got somebody who's like, she's not entitled to maintenance because she had the affair in 1983. Let's say the affair was this year and it might actually matter, or let's even say she's actively with somebody who might or might not be supporting her. You've got some reason to think that she might not be getting maintenance. Here's a little trick I learned from the fancier lawyers when I started doing more of this. You can just give her money and reserve the characterization of that money, right? You can get an order that husband will pay wife $300 a month in child support and an additional $200, the characterization of which is reserved for further adjudication or agreement of the parties. Guess what? Nobody ever comes back and actually figures that out. So we do this all the time. Was that maintenance? Was it not maintenance? It doesn't really matter for tax purposes anymore. Was it an advance of her marital interest? Maybe, maybe not. You can just get her money and reserve the characterization. And there's really good odds that when you are finally settling this case, he will not remember to care about that. And she will have just gotten some money. So there's your free tip of the day.
Is that in your outline or?
No, it's not in mine. I didn't write the outline. Yeah. Make note of it, but do make note of that. It's real. It's a nice trick because people do forget about it. And it's not a trick. I mean, it is sort of a trick. But you know, that's on him and his attorney that they didn't come back and ask for that. Flip side, if you're representing Joe, be careful about that, right? Be careful not to leave yourself an open-ended issue that you know you're not going to come back and do, right? So no, thank you, that's good. So yeah, so you're there, you're in court. There's a decent chance in Fayette County you'll be sent to go see the in-court mediator at motion hour. I don't know how many of you all are practicing in the county with in-court motion hours in family court. We're trying really hard to get them expanded. The Bar Association has been granting mediators, not a lot, but enough to try to get some of us out into the other counties to mediate at family court motion hour, family motion hour. So you might see a mediator, you might get this done. The judge might just have to rule. Here's the thing, your ruling is temporary at this point. Whatever you've got is temporary, and nothing a judge does in that first temporary hearing can't be undone, right? It can all be undone at that point. The judge that I clerked for is no longer practicing, no longer on the bench here. She's retired and moved away, but she had no ego about making temporary orders. She was like, well, if I got it wrong, we'll come back in 2 weeks. I mean, you know, they really are, at least around here, pretty good about just doing something so the bills are paid and we can move on and you all can kind of calm down, right? Like once there's an order, everybody kind of settles into the routine of how this is going to be. Maybe eventually things calm down and they come up with an agreement. So don't feel like it has to be perfect. Just get your order, get something coming in for Susie. What about custody and parenting time? What do we think? Joe's not around. Is that kind of his problem? Yeah? Yeah, I kind of think so. I kind of think Joe needs to show up and take some initiative here. Now, Joe's going to come to court, and he's going to say, well, I don't mind paying, but I want to see my kids if I have to pay, right? I mean, that's what he's going to say. Okay, fair enough. I assume a lot of you all have kept up with the recent legislative changes. Joe is now presumed to have joint custody in equal time. I think it's going to be hard for Joe to get equal time off the bat. I will say, most of the time around here, I think a judge would say that is, you know, him disappearing for 3 weeks and not seeing the kid is good cause not to throw him right back into it. But probably he's going to get some visitation, right? Some time sharing, parenting time, whatever you call it. Neither time sharing nor parenting time are anywhere in the statute, by the way. But our newest version of the rules, which should come out later this year, will just basically bless calling it whatever the hell you want to call it. He's probably going to get some time and see how that goes. And if Joe shows up and he regularly is exercising time and he's able to graduate and slowly build his way towards an equal time sharing arrangement, that might ultimately happen. I don't think it's going to happen right off the bat. My predictive powers aren't perfect. Maybe he makes a great case to the judge. Maybe the judge lets him try it. I don't know. So you've got that issue out there. I didn't say a whole lot about that here because it looks to be kind of taking care of itself, and there's some other issues that I wanted to make sure that we hit on. Your materials go into great detail about all kinds of things you can do with custody and time sharing. These were written, I think, by a lawyer in Jefferson County, so a lot of that is Jefferson County specific. Know this, fighting about custody is expensive. The highest fee case I have ever had was not a property case. It was not the wealthiest person I represented by far. I have represented multimillionaires. I've represented 100 millionaires. The most expensive case I ever did, the marital estate was a Honda Pilot and an IRA with $13,000, and they were fighting over that kid. We had custodial evaluations. We had independent psychiatric evaluations. We had evaluations in Cincinnati. We had evaluations in Louisville. Everybody evaluated them people. It gets expensive fast, right? Because those are like 10 grand a pop. Yes, sir.
If you're doing one of these pro bono for legal aid, it's paying them.
Yeah, so nobody, so it doesn't get ordered, right? That's good news for you. My client had First National Bank of Mom in her case, and that kept that going, and he had First National Bank of Mom. They're very young. That kept that litigation going forever. In Fayette County, how many of you are here in Fayette County or practicing largely here? All right, good. So here we have the friend of the court's office, which will do a custodial or time-sharing evaluation at a sliding scale basis, maybe as much as 25 or 50 bucks a party, maybe even waived completely for you in your pro bono case. You have some options there. Here's the thing, y'all, and I did not say this. 90% of these things come back and say, Mom has some strengths and weaknesses. Dad has some strengths and weaknesses. Mom's strengths and weaknesses and Dad's strengths and weaknesses are exacerbated by the divorce. They should work together to come out with a schedule that works best for the children and maximizes the amount that each of them can have. 99% of them say that. I mean, I could write who's here? All right. So everybody's like, oh, would you get a report with Dr. Feinberg? I could write it blindfolded right now and tell you what it's going to say. I mean, they say one time in 10 years, and I have deposed the man quite a bit, and I respect him greatly. One time in 10 years has he said anything else. And it was bad. Like, mom took the kid to Florida and left her at a rest stop. And guess what? We're going to recommend joint custody and slightly unequal parenting. I mean, it is, they never come up with, and psychologists never get it, right? Because they're used to seeing the worst of the worst, right? I had somebody lately in an evaluation, and she was doing a risk assessment, and she was like, well, mom's risk of violence to the child is only low to moderate. Like, well, what does that mean? Like, is there a 40% chance she's going to strike the kid? And like, is that okay? Does that mean we're in good? I mean, I don't know. So those things are very expensive. Judges really don't want you to fight about this, is the other thing, right? They are going to bend over backwards, not just set a time-sharing schedule. The way you can help Susie do that is you can help Susie stay in mediation. You can propose something to Joe or his lawyer. If I were working for Susie, I'd say to Joe or Joe's attorney, well, why don't we do this? Let's try something graduated. Joe's been gone a minute. I know it was an instant reaction. I know it was hot-headed. I know it's going to calm down, but why don't we do this? We'll do, 2 days a week for the first month, and then we'll graduate to this other thing, and then we'll graduate to this other thing, and then they'll review, and by that time you'll have them divorced and they're not your problem anymore. Something like that is probably what I would propose to try to keep them out of there. Keep in mind, they have to go to parenting class. Families in Transition is back in Fayette County for children, I want to say over the age of, it's either 5 or 7, I don't remember. And all parents, you'll get an order about it. Make them go. They don't think they need to go. No one in the world thinks they ever need to go. I have clients who are paying me real money to go to court on joint motions to waive FIT because they are so sure they're such great parents. And I'm like, if you want to spend $500 on this, that's great. But let's say you're right and your kid's really traumatized by going to the class, take them on a $500 vacation. There's other ways about it, but people are spending a lot of money on that. So check your local practice. We've talked a little bit about maintenance already. I'm not going to delay that too much. Keep in mind that maintenance is modifiable and terminates upon all kinds of circumstances that are sometimes hard to prove, sometimes not. Lawyers have robust disagreements about this, but I would almost always rather have property than maintenance. I would almost always rather have enough property for my client to support herself or himself than have to rely on maintenance and paying a lawyer to enforce it. I don't know. I think my marriage is good, but my spouse makes a whole lot more money than I do, and I don't think I want maintenance. Because I just wouldn't want to have to track it down, I wouldn't want to have to enforce it. I wouldn't want to have to go to court. I would rather you just give me an unequal division of property to account for the fact that he can replenish the marital estate better than I can. So. Speaking of marital estate, let's talk briefly about what they need to do with property. We've talked about the house. Susie may just be SOL about this house, you all. I don't know. The mortgage on let's say the mortgage is $115,000. I'm not the financial genius. That probably means the mortgage payment is what, $1,000 a month, something like that. Anybody know these sort of things off the top of their head? It's probably going to be in the low thousands. I don't know how she can afford this house, even if you get her maintenance. There's not a lot of equity in it, so if you sell it, maybe she gets the equity as a lump sum and she can use that as a down payment on a smaller house. I don't know where in Lexington she's going to live, by the way. That is a speech in a soapbox for a different audience, but I don't know how she can afford to live anywhere. You've got an issue there. There's not a lot of other property. You're going to want to figure out what he's got in his UK retirement. That's probably the biggest and most interesting thing here for me, kind of buried out there. You have it's tricky, you're going to need information in order to make a settlement or proceed to a final trial. The way you formally do that is through the preliminary verified disclosure statement. There are links to those in your materials. There are 2 versions. You're welcome. I was on that committee. One, if you have less than $100,000 in income or property, you can fill that one out. It is half the length of the other one. You've got some options there. So you want to fill that out. You want to serve it on him. He's not going to get you his on time. So you're going to have to file a motion to compel him to give you his financials. You're going to have to pull some teeth there. Here's where it gets interesting though. She's not going to believe whatever he wrote under oath, nor should she, right? Has anyone ever seen a prosecution for perjury in a family law case? I don't think they happen. I think the judges kind of assume that everyone is lying. Right? I would assume everyone is lying. And so she's never going to believe what's on the piece of paper. And then you have to start talking about how much pro bono work you want to do for her. Because she's going to think he has some other account at some bank. She doesn't know the name of the bank. She doesn't know the amount of money. She thinks maybe it's a bank with an office in Louisville. And that's what she knows. And she's going to want you to subpoena every bank in Louisville to run a search to see if he has this sort of thing. I've done this a couple of times. I've done this for rich, paranoid people who just had basically paid for my recent vacation in Aruba by subpoenaing random banks to see if guys had accounts there. They think that because you're a lawyer, you're going to like go check some computer and be told everything. Nothing could be further from the truth. And the bank is not going to want to deal with you, right? Like especially these big banks, these big telecom companies, they aren't going to do diddly squat for us little state court attorneys in Kentucky, right? I mean, they're going to respond to your subpoena at the last possible minute and say Joe Smith does not have an account here. You have to make some decisions there. There are lots of sophisticated things you can do at this point. You can do a lifestyle analysis using his tax returns, figure out where the money went. They have 3 kids. I know where this money went, right? I mean, they are raising 3 children on $60,000 a year combined. They have a house. They have 2 vehicles, at least one of which has a payment. This money is going to go real fast. I would love for Joe to be hiding money. I think it would be great if he were hiding money. It would make this case a lot easier. He's probably not. So you'll deal with that. Eventually you'll have enough information to make an offer. Right, this is the idea. As soon as I get the PVDSs, what I do in my office is I sit down, I read through both of them at the conference table, I highlight discrepancies, figure out if there's anything I need to follow up on. I make myself a little spreadsheet of the marital assets and debts, figure out a way to divvy them up properly, and then I write that as a settlement agreement and send it to opposing counsel or opposing party and say, hey, check this out, let me know where we are on this. Here's another random tip from Ross. When you are negotiating a settlement, I find it eminently and infinitely helpful to negotiate with an actual settlement agreement. Lawyers love to send these little letters back and forth, well, we think we would agree to this if you would agree to that, and we might agree to this, and then they get to this agreement, and then they go to write it down, and it turns out they have 17 remaining disagreements because they weren't actually negotiating how it was going to work. So this is just a practice tip from me. An agreement in principle is not an agreement. If you have a meeting of the minds on the architecture of something, you are nowhere near done. Don't celebrate that. When I send you a settlement offer, I send it, you can sign it and send it back to me that day. Like when I make you an offer, I make you a sign and return to me offer because you're gonna have to deal with all those details at once. And here's the thing, if you save some of the details, divorce is like a Jenga puzzle, right? Like you've got maintenance over here, and you've got property here, and you've got support here, and you've got time sharing here, and it has to all work together. If you pull one piece of that, even if you agree on what everybody's gonna pay, but you don't agree on what day of the month it's gonna get paid, right? That messes up everything, right? Let's say you've got this whole agreement, but you've got to get child support in on the 1st of the month to make the mortgage by the 15th, and then she's got to pay the medical bill by the 18th. You need a complete agreement, and you need to think through it in those kind of practical ways, or else you're not really getting anywhere, in my opinion. Yes, sir?
Share a draft settlement agreement and your asset spreadsheet.
Sure, yeah, absolutely. So my contact information is in your materials. I would be happy to share with you a settlement agreement and an asset spreadsheet. Keep in mind on settlement agreements, they are not entirely one size fits all. I have a sort of master that I use, but there are some things in there, particularly relative to bankruptcy and enforcement and that sort of thing that you may or may not be on the right side of, right? But boilerplate is not neutral, I guess is what I'm saying. I have lots of boilerplate versions in my office, and they may all look the same to unsuspecting people on the other side, but they are all in my client's favor, right? If I send you one, I have 2 different versions of the bankruptcy boilerplate, and I'm going to use the one if I might file, and I'm going to use the one if I don't ever want the other guy to file. One or the other, I'm not going to use both. So keep that in mind, but yes, I'm absolutely happy to share that. These people don't have a lot to fight over. I would hope, really hope that they could settle. I don't know that I believe every single case can be settled in mediation, but I'm pretty darn close to there. I've settled cases in mediation with domestic violence. I've settled cases in mediation with people who are truly mentally ill. There's a way to do it if you do it right. Here's the thing, settling a case is work, right? Some of you ought to do, you know this, like settling a case is work. It's a lot of work. Going to trial is still more work. It's still more work for you than settling a case. So I think there's some decent chance that they'd settle. I know somehow I have talked the majority of my time already. I want to talk about a couple things real quick. Well, two things. Before we go into the variation, concluding the representation. This is so important. I love closing files. It's like my favorite thing. Really, it's like my favorite day of the quarter when I close files and put them in storage. It just makes me really happy. There's something kind of instant gratification about like closing it and moving it off my desk, and it feels very physical. It's very gratifying. So let's talk about how you're going to close your file with Susie when you're done. So the case of Murphy versus Murphy tells us that in divorce, as a matter of law, your representation terminates upon the entry of the divorce decree. I don't know what your particular legal aid or pro bono program provider will have to say about this. They may have a slightly different set of expectations of you. The important thing is to get those in writing, okay? My engagement letters say that I will represent you through the entry of a decree and the entry of any orders called for in the decree or settlement agreement. So I buy myself a little wiggle room to do quadros, which we haven't even talked about, to do that kind of stuff. By the way, Joe works at UK. If that means he either has Fidelity or TIACREF. They are very easy to provide. If you get one of those, feel free to call me. I've done them a whole bunch. Once you've got an agreement on what to do, those are the big brokerages can be form intensive, but it can be fairly straightforward. Sorry, I got off on the tangent again. But I want to make it clear. You want to make it clear with the pro bono office what's expected of you, and then make it clear to the client. That's what I would do. All right, so I want to skip to variation number 3. We're going to do these out of order because I want you to be on the cutting edge of what's happening in family law. So all the facts are the same, but Joe is short for Josephine, and she's a woman. What, if anything, is different?
So is this female and female?
So
I don't think that there- on the one hand, I would say that there's nothing different, but in the reality, when it comes to certain things, like for example, with regard to custody, good thing is now that things are specific, whereas the equal time share, I mean, it starts to be an issue with regard to some, well, this is a woman versus woman, so issues of insurance may sometimes come up. And other things that typically wouldn't be an issue if it was a male and a female, so you have to kind of think about those from that perspective.
Yeah. So here's the fun fact: gay people can be poor. You wouldn't think about it like the way we're portrayed in the media. We could be really poor, right? So this case could totally be 2 women. There are a couple of things to think about. On the property side, I think it's fine. I think you're there. There's no difference. Here's what's really interesting to me. It's going to be determining custody and parentage of the oldest child, right? You're going to have some hooks here. The younger 2 children were born during the marriage, so they are presumed children of the marriage. We're okay-ish there. You may have to do some work about this older child, and if Joe decides to become difficult, Josephine could make this very difficult, particularly I think with regard to that older child who was born prior to the marriage. You want to know if they had some custody agreements, have they done any family planning? I have a whole other CLE about parenting a child who is not your biological child. We've done it a couple times. Make sure you check the case law on this. It is changing rapidly, so rapidly. You're going to have some issues regarding parentage and how that happens and what you're going to see there. I would hope that the 2 ladies who've been together this long will be good about it, but you can't guarantee it. I shouldn't be telling you all this, but I'm going to because I really want you to do good work. So I am on a listserv, a national listserv for the National LGBT Bar Association for family law, right? We talk about family law cases, family law problems about parentage, surrogacy, maternity, paternity. We have a nickname for a certain type of case when we are sending each other emails that is just the NRA LBB, lesbians behaving badly. And that is what this case has the potential to become. if Susie decides that she is the only parent that Adrian has, right? She may be in some very technical senses correct, and what you need to do is you need to find what the outer limits of her constitutionally superior right to parent her child is. Has she waived it? What has she done? You're gonna have some work to do in that case. Or it could be fine. You know, I had, the day that the Obergefell decision came down, I had a case that had been sitting on Judge Masterton's desk as a submitted divorce for like 3 months. And the judge came in and said, please don't make me rule on this. Please let the Supreme Court tell me whether I can divorce these ladies first. And I said, that's fine. They'd settled the whole thing in mediation. They'd agreed to a child support deviation. They'd agreed on funding private school. They had done the whole thing. It was just fine. You know, none of the technicalities came up. It really depends on who gets in Susie's ear about it. Yeah, yes, sir.
But in terms of custody though, both parents would have like an equal claim to custody? Or
Whoops.
only the parent that carried?
Yeah, so it depends on what you mean by parent, right? So
Well,
there is
they're
no
both
legal
parents.
definition of parent in Kentucky. There's not one. We
I
don't
mean-
have a definition of maternity. We have the Paternity Act. We have no definition of maternity.
But they're married, so they're both
Right.
parents.
And so I think it helps, right? A child born during a marriage is presumed to be a child of the marriage. The question is, do you rebut the presumption by the absence of sperm? Right? I mean, like, that's what you're gonna have to argue, right? Like, I don't wanna watch that argument. I've been asked to make it,
No,
I decline.
and
Right.
speaking
Yeah, no.
speaking of sperm though, that adds a third person to the.
There could be a third person out there, right? And that's the other CLA I do, and we figure out, is the guy known, and is he an ex-boyfriend, and were they ever really together, and is he parenting, and yeah, you've got some issues there. You're good on support. There is a recent case, I can't remember, oh gosh, I can't remember the case name. It was Judge Fleming's case down in Western Kentucky. It's Commonwealth versus somebody. And I never thought it was family court because I don't read cases that have Commonwealth versus somebody in them because they usually don't apply to me. But the holding in that case is that you can force the other mom to pay support even though she may or may not technically be legally the parent.
Oh my gosh.
So there's that, that's out there. Do you all work with Judge Fleming? Yeah, I adore Judge Fleming. We're on the rules committee together. I think the world of him, but he's too smart for his own good. I mean, really respect the hell out of him. But he is so proud of that case, man, and he will just talk about it and talk about it and talk about it. And he'll tell you about how he gave them New Jersey law, and he figured out the New Jersey code to make this woman pay child support. Tons of respect for Judge Fleming. But it's, you know, it's good. It's a belt and suspenders approach, right? It's a belt and suspenders kind of case. It's out there. You've got some support for that. That's the thing to think through. I think we have an ethical obligation to treat them as much like any other couple as we possibly can, right? I think that's our basic goal, is treat all of our clients with dignity and respect, and I think that we need to do that to the maximum extent possible. I think I'm out of time. You've got my contact information. Thank you for doing the pro bono work you're doing. If you are in your pro bono case and you are stuck, please feel free to call me. I mean that quite sincerely. Thanks.
That was really good. You went real fast.
Sorry.
No, it's good. It's good. That would be awful. And then, you know, the kid calls him mom. You see him.
All right, we are in the home stretch. Our last topic is basic estate planning. Our speaker is Katie Fennell. She graduated from the University of Kentucky and